am Bonnie Steinroeder, and I'm the pastor.
And I'm John Moore, and I'm the policeman.
We are so excited that you're joining us this evening for the opening of our second season of The Pastor and the Policeman. Tonight, instead of looking and zeroing in on a particular constitutional issue, we're going to be taking a larger look at a book called The Living Constitution.
The name of the book is The Living Constitution by David Strauss. And we read through it. We both got a lot out of it, but the best thing to announce to our viewers tonight is we have a special guest, and that guest is Judge David Cunis. He's the first justice of the Framingham District Court, and he also lives in town. So we want to get an expert view in terms of what he thinks in constitutional interpretation.
Yeah.
So the book itself talks about two different areas. One area is originalism, which is looking at the Constitution and trying to determine what the founders meant by what they wrote. The other version is the living Constitution, which is when a jurist looks at the Constitution, it should be from his or her viewpoint in the present day. So two very different interpretations. Go ahead.
Great. Well, see, I'm ready to jump in, and I said to Judge Kunis before, I said, I really want to pick your brain about this, because not having a background myself in law, in the Constitution, the first thing that I thought about when I read this book was it's a little bit like interpreting the Bible. Right? So there are some people who will look at the Bible and they'll say, we read this literally. Whatever the Bible says, that's exactly what we're supposed to follow today. And then there's someone like me who looks at the Bible and says, there's truth in here and there's a lot of wisdom in here, but we have to look at it through the lens of modern day people, and what message does it bring for us as a modern people? And so I wonder, is there any kind of correlation between how I would look as a minister and interpret the Bible and how we would look and interpret the Constitution? Literalist versus, no, we have to make it work for the modern times. Mm-hmm. And so I'm so interested to know, as a judge, some of your thoughts on maybe the pros and cons of the different approaches.
So before we go into that,
we should introduce our guest, right?
Well, yeah, I'd like to give a little more background on our guest. I've known Judge Cunis for almost 30 years. And we first met when I was a criminal defense attorney in Framingham District Court, and he was with the District Attorney's Office. So he was a prosecutor. I was a defense attorney. Over time, over that period of time, the judge has become a judge, and I went into law enforcement. So it was kind of a different path. We crossed paths. And now, like I said, he's the first justice of the Framingham District Court. He knows quite a bit about interpreting laws, interpreting the Constitution. But first and foremost, he's a trial court judge. He does trials, but he also does some work on the appellate court. So, Judge, I'd kind of like to ask you right from the very beginning, what's the difference between the trial court and the appellate court from your standpoint?
Well, the trial court, we try cases. We try civil and criminal cases, conflicts that arise. And in the civil setting, we have civil cases involve lawsuits. Mm-hmm. Someone will sue another party, private parties. Where we have the criminal law, we have the prosecution, or the government will bring a criminal charge against someone for violating one of the criminal statutes. So in my court, we try those cases. Now, if you're convicted, the defendant in a criminal case or a litigant in a civil case has a right to appeal an adverse decision or adverse judgment in a civil case, or a conviction in a criminal case. And so the appeals court, when you appeal to an appellate court. In Massachusetts, you appeal to the first you appeal to the appeals court. It's called the Massachusetts Appeals Court. And then there's the Supreme Judicial Court of Massachusetts, which is the highest court in the state. Most cases, when you file an appeal, you're going to be going to the appeals court. The SJC, as we call it, Supreme Judicial Court, they hear certain types of cases. All first-degree murder appeals will go to the SJC in the first instance. They bypass the appeals court, which is, the appeals court's like a middle-level appellate court. And the SJC also, if there's a ruling in the appeals court, someone has the right to go for what's called further appellate review, and they can take the case up. They can request the SJC hear their case. And that doesn't happen too often, but it does happen. When I was in the DA's office, I did both trial work and appellate work, and I appeared at the SJC quite a number of times, and at the appeals court, obviously dozens and dozens of times. So that's the appellate. Now, the appeals court deals with only issues of law. The facts were settled back in the trial court. The facts are the facts. The facts, the jury finds someone guilty, any type of factual finding is settled in the trial court. It's the legal issues. Was someone's rights violated? Should the judge have allowed a motion to suppress evidence under our Constitution? Was there a Fourth Amendment violation? Was there a Fifth Amendment violation, like a Miranda violation under the Fifth Amendment? Did the police fail to give someone their rights? Did they not give them their rights, their Miranda rights, as we call them? Were they not given correctly? So these are issues which, if they're resolved against the defendant in the trial court and he's convicted, he can then appeal those legal issues to the appellate courts.
Right, and those are not interpretive. It's like either his rights were violated or her rights were violated, or they weren't, or is there
they are
interpretation?
interpreted. There's certainly interpretations, absolutely interpretations, in both the Massachusetts and the federal Constitution. For example, your average Fourth Amendment issue, say involving a search warrant. Police obtain a search warrant to search someone's home. Incriminating evidence is recovered. That evidence is introduced at trial. Now, usually before trial, a good defense attorney is going to find something about that search warrant that might not be correct. Maybe there wasn't sufficient probable cause to actually have the warrant issue. And he'll raise that issue before the trial judge. You have to raise it before the trial judge, or else you waive that right. So you raise that issue before the trial judge. The trial judge will look at the warrant. He'll rule on it. He'll say, no, I find there is sufficient probable cause. Your motion to suppress evidence is denied. If he is convicted after trial, he can take that issue and bring it up to the appeals court, or the SJC, as the case may be. The SJC will take a look at it. And again, it is also a matter of interpretation. The SJC could say, you know, the judge below, the trial judge, interpreted the law incorrectly, and he should have allowed that motion to suppress evidence. Yeah, it is a matter of interpretation.
But there's no bright line rules in terms of most of the language in the Constitution, especially the Bill of Rights. I mean, you cited the Fourth Amendment,
right,
and you talked about probable cause, and you talked about reasonableness. So when a defense attorney argues before you, Judge, I don't think there was probable cause here, that's his or her interpretation of what probable cause means.
Correct.
And then you come into the picture and you give your interpretation, and then at some point, it might be an appellate court or the SJC.
Absolutely. Yeah.
Same thing with reasonableness. Judge, this was an unreasonable search and seizure.
Correct.
It's their interpretation, it's their opinion, and then you interpret it as well.
But you see, you're kind of making the book's point then in a way, because part of what he's saying, and again, back to my, don't always mean to bring it back to the Bible, but the same kind of thing, the way you interpret it, he's saying, in a way, originalism can't exist. That he said there are certain things, like in order to be president, you have to be 35 years old. That would be one of the few things that there would be no interpretation. Or maybe with someone read their rights, they were probably read or they weren't read. But most other things then fall under what he's saying is that it's impossible to do the law, to work the law, to be a judge, and not bring your own experiences, your own interpretation to it, no matter what it is. So kind of to encapsulate some pure kind of originalism, he would say, is not possible.
Right. Well, he looks to what he focuses on here, and I have to say the book is very good, and I think he does do a nice treatment of what we know as the common law. When I decide a Fourth Amendment or a Fifth Amendment issue, Fourth Amendment is usually the search and seizure issues. Fifth Amendment usually deals with interrogation, whether someone has been given their Miranda rights. It's a Fifth Amendment issue primarily. I never look at the Constitution. I've never actually had to go back to the language of the Constitution. I mean, I may cite to it if I'm writing a decision, but I'm citing to a case that's citing to it.
Right.
You always go back to the case law.
Right.
Common law, and I think this is an important point, is that the two types of law that we have. We have common law, which is judge-made law, law that courts over time it's a development of the law over time.
Like precedent. Yeah,
it's precedent. It's decisions, opinions of various courts, mostly appellate courts. Although if I were to write an opinion, someone could consider my opinion, my written opinion in a case, law. I mean, it could be if it hasn't been overturned. Someone could say, well, Judge Cunis wrote this opinion on a search and seizure issue. It was never appealed. This is good law. I mean, usually it's not law that the SJC is going to rely on, or no one else other than the lawyers who usually appear in my court. But that's judge-made law. But typically, the law that we deal with, the common law, is the law of the Supreme Court of the United States, the SJC, the appeals court. That's common law. Then the statutory law, which is the law that the legislature makes. But as far as looking at common law, it's that's what I rely on primarily in my work when I'm looking to decide a particular issue in controversy. Defendant files a motion to suppress. He argues. The prosecutor puts on evidence. The prosecutor argues for their point of view. I'm the one who has to make the decision on it. Now, I could certainly be wrong. My interpretation of the law could be wrong. And I have been reversed on appeal. I think every judge. I'm
sure everybody.
Every judge has been reversed. I mean, if you haven't been reversed, I'm not really sure if you're really doing your job.
Right.
I think you have to. Sometimes you have to take some. There are safe issues. There are decisions that are pretty safe. There are decisions that are pretty much, you want to call it slam dunk.
Right.
Most motions to suppress. I mean, and this is not my view, my point of view on it, but I think most motions to suppress are denied. But I certainly have allowed a great many of them as well. And that's and if they're allowed, it's usually it's pretty much a slam dunk with the police or someone did something wrong.
Right.
Like, for example, just not giving someone their Miranda rights, or giving them only partial rights, or searching without a warrant where they had to have a warrant. I mean, these are issues that are pretty much black letter law. But there are those issues which you really can't say from what the correct decision is. I have to call the balls and strikes. Could I be wrong? Yes. Have I been wrong before? Has the appeals court told me I'm wrong? Yes. And that's part of what being a judge is. You have to make the calls and then see what happens afterwards.
You made a good point earlier, and I just want to go back to it for a second. So you write an opinion in district court, and that would be considered persuasive. An appellate decision would be precedent. Right. So for our viewers, I, as an attorney, could go into court and say to another district court judge, Judge Cunis wrote an opinion 2 weeks ago, and here it is, and I think it's persuasive. It's not precedent yet, but maybe it will be someday. The other thing is, and maybe you can speak to this, or Bonnie, you can as well, I think a lot of times in terms of appellate opinions, they will give you their interpretation of the law, but they will also make a suggestion to the legislature saying, if you want it to go a different way, you have to write a different law. Right. So whether it's you write a law, or if it's a constitutional matter, maybe you amend the Constitution. Right. So what are your thoughts on that?
Yeah, it does often happen in SJC opinions where they invite the legislature to take action. Like this is an area that the legislature needs to address. Right. And that does happen, and the legislature usually does, or sometimes the rules committees, they make a change in the rules, the rules of civil procedure, rules of criminal procedure. So yes, it does happen. Yeah, my opinions that anything I write, for example, there was one opinion I wrote about back in 2012 regarding what are called DREs, drug recognition experts. Right. And there's a lot of controversy involving whether drug recognition experts, they're basically police officers who've been given this 80-hour course in identifying whether someone is under the influence of certain drugs, and whether that evidence should be admissible in a trial.
Because they're just evaluating them without any
Well, they're not experts in the sense where they've had medical training in certain areas of identifying whether someone's eyes, how their eyes move, a nystagmus they call it. So I wrote this 12-page opinion in which I was hoping that someone was going to appeal so we could get some good guidance from the appeals court. Sure. No one ever appealed it, and that 12-page decision is still all over the state. I have it waved in my face all the time. Judge, you wrote this 7 years ago. Right. And one of my colleagues said, he said to me, well, it's still good law. So is it law? I guess it would be law, but I would say it's persuasive law, as you said. It would not be precedent. It might be precedent in my courtroom,
Right.
but
I mean,
an appeals court could just toss the thing
Yeah,
aside.
but I mean, if it's a very novel issue, and that's one of them,
Yeah.
and there's nothing else on the subject, they're going to go with that.
Yeah, and people have been going with that opinion all over the state now, defense attorneys, all over the state now for 7 years. And as far as appeals courts go, I actually sit on an appeals court myself. There is an appeals court within the district court called the Appellate Division of the District Court. And it is 15 judges who hear appeals of judgments in civil cases in the district court. We do civil. We don't hear any criminal cases. So if you have a judgment in the district court, an adverse civil judgment, you can appeal it to the appellate division. And we sit in panels of 3 judges, and we write opinions, which do have some precedential value for the district court. And I'm on that appellate division, which I enjoy because I get to do a little bit of writing and research.
Now, when you think about it, you know, our system of government is set up in such a way that we have 3 branches: the executive, the legislative, and the judicial. So the executive branch, in the form of maybe law enforcement, takes an action. And then it's reviewed and maybe overturned by judges. And then judges might instruct the legislature to write a new law if they want a different result. So all 3 branches are involved, checks and balances. It's actually the perfect mix, and I think it's what the founders were looking for when they wrote it.
When it works correctly, right?
When it works correctly, which isn't every day, but...
Well, I think the problem now, as with everything else, the whole concept of judges has been politicized, and I thought it was very interesting that the Chief Justice of the Supreme Court came out fairly recently, a month or so ago, and he said, you know what, John Roberts said, there are no Trump judges, there are no Clinton judges, there are no, and I think that was pretty extraordinary for him to come out and to try to make that statement. And the way that I interpret that, he was saying, hey folks, you're politicizing us, and it's not good for us, it's not good for you, it's not good for the country. And yes, every judge is a human being and is going to bring their own lens, their own life experiences. But I go into it assuming that a judge is a judge because they want to try to be fair. Right? Absolutely. They want to try to live out the law. But that must be a very hard thing when we live in such a politicized country to be a judge right now on any level, I would think.
Judges should not approach the job with an agenda, with a political agenda. I think that's where I think going back to common law, where you have there's just centuries of common law in our country going back to the founding. Back to the Constitutional Convention when they created the Supreme Court of Massachusetts, the Supreme Court of the United States. We've had a wealth of decisions from all these federal courts, the Supreme Court, all the lower federal courts. There's so much out there that we can rely on. We don't need to be making things up ourselves. We shouldn't be. That's not our job. We're to rely on, the Constitution is our framework, but the common law that's been developed over the centuries is what we typically look to and what we typically need to follow.
So here's the question I have, and maybe the answer is through amendments, but so we have society, and when the framers wrote the Constitution, they were living in a very different time, a different place. The customs and the norms were different. So, for example, women were given the right to vote after African Americans were given the right to vote, and these came through the form of amendments. So do you think that's the best approach? Because society is going to continue to evolve, and one of the things about originalism that I think is difficult, we have to try to put ourselves then in the place of a person who lived in a very different time that would have different assumptions, and the world looks so different. So how do we stay true to the Constitution, but also allow it to reflect how modern society changes?
I think the Constitution has the answers, and the answer within the Constitution itself is why you amend the Constitution. I mean, and one of the things the author did was he sort of gave that somewhat short shrift. He sort of said, well, in the beginning he said, well, we can amend the Constitution, it's there, you can do it, but it's hard, it takes time, and so he just kind of glosses over that, where I think that's really something we need to look at and that, you see, amending the Constitution involves you know, involves the people. That's how the people get
Involves the whole country.
Right, the whole
Right.
country. You know, you have to have the 2/3
Right.
of the if there's an amendment to approve it. I mean, that's where the people really get involved in writing and changing their constitution and their laws. Now, can you do that all the time? No. It's as you said, 27 times it's happened. But it is possible to do it, and I don't think you should simply dismiss it because it's too hard. The other thing about originalism in his book, he tends to focus, what I noticed, focused on originalism as being looking back into the minds of the founders.
Yes, he talks about that a lot.
You know, and you know, we don't know what they were thinking. Well, we do somewhat know what they were thinking because of the times they lived in. So we get a sense of what they intended for us as a nation. But they did live in a different time than we live in now.
Yes.
I don't like the word originalism too much. I like the word textualism, or being textual. Look at the words they use as opposed to what was going on in their heads. You can give a reasonable interpretation of the words of the Constitution, and you can have that living Constitution, but you're still bound by the words. And if you don't like the words, you have the amendment process.
I love that.
So I'm not a big, the whole
it.
notion of originalism I don't like. I like textualism. I think it's a better way of looking at it. Look at the words themselves. And you know, there's all kinds of reasonable interpretations from the words. You look at the Miranda rights, which I deal with every day. Are they in the Constitution? They're not. Can you reasonably infer or pull from the Constitution the rights, the Miranda rights? Yes, you can. I mean, if you look at the Fifth and the Sixth Amendments, that, you know, it's there. I mean, you have to, you know, it was developed, you know, through the Supreme Court.
Yeah, I mean, I don't think it's a binary choice where it's one or the other. And if someone says to me, I'm a strict, you know, constructionalist or originalist, and I won't look at anything other than that, well, it's both. Just like the judge said, you know, part of your analysis has got to be, what do the words say? What do they mean? On the other hand, even if it's a precedent can be changed. And we've seen that, especially in regards to, you know, racial equality.
Sure.
And like the judge had said, you know, the Miranda rights are not in the Constitution, but they are part of the Fifth and the Sixth Amendment. Same thing with the right to privacy. It's not in there.
Right, and we said, but Roe was founded on that.
We have adopted a right of privacy, or at least we've interpreted what we've read to have that in it. So.
Or you have like Brown versus Board of Education, which, you know, if you look at the Equal Protection Clause, look at the words equal protection. I mean, what you can reasonably take from those words. Can you get to Brown versus Board of Education from those words? Sure you can. Is it a reasonable development from the words, equal protection of the laws? Sure it is. So yeah, you know, again, I think that the whole looking at the text and a reasonable interpretation of the text. You don't want to go, that's where I think, you know, people talk about judicial activism. You can't go making stuff up and, you know, finding little things in there where they're not there. I mean, and that's where I get to, you know, that's where I think you have to say, okay, hold on, let's talk about an amendment.
Well, I mean, when you go back to Brown again, and Bonnie and I talked about this at length, so the decision from the U.S. Supreme Court was in 1954. Well, it took another 10 years before all the civil rights legislation came through in the 60s. And then it probably took another 10 years before the executive branch, by way of maybe law enforcement or other mechanisms, it got forced. So it's a perfect, well, not a perfect system. It's the best system, but it's imperfect. And in that case, it involved all three branches.
I think the problem with judicial activism is that each side will claim when they don't get the decision they want, right? So if a judge has a decision that I personally like, I'm going to say that's a great decision. If I don't like it, I'm going to say, oh, that's judicial activism. And I think, again, it's a way that we devalue just what you're saying, the system. And whenever I hear, mostly it's Supreme Court decisions that have the biggest, but when I hear, you know, 7-2, I'm like, yes, that's great. Like, I don't want to hear 5-4. I don't want to hear, I want to hear that people were able together somehow to come out with a decision that wasn't partisan. And that's what I'm afraid so much that we're losing. And I think, I know that I long for it, and I think that other people do too. Sure. But what you were saying before, right? It's, so you get Brown, but then you also have the 15 equal protection. The Supreme Court decided very narrowly also applies to marriage equality. Right? Mm-hmm. But there are a lot of people who would say, well, that was taking it too far. It doesn't. And that's when I'm like, well, right, you can't go back into the minds of the framers because they weren't thinking about marriage equality. You know, back then they didn't have a word for it. They didn't, it was so different. So you have to take the words and say, what does equal protection then really mean?
But don't you think to a certain extent, and it plays into the argument in the book, that they left these terms open-ended to be interpreted in the future? I mean, we talked about probable cause, we talked about reasonableness, we talk about equal protection. I mean, it's not like someone comes into the judge's court and says, according to the Constitution, and it's not written this way, but according to the Constitution, you need 3 witnesses to establish probable cause. They have 2, and rule against it. Mm-hmm. That's not the case. It could be 1 witness. It could be 10 witnesses and no probable cause. Mm-hmm. So they left it open for us, which I think is a good thing.
I think it's a good thing too, but I love what you said before about we can't ever, I can barely get into the mind of someone in my own day and time, right? Yeah. Someone that I know well. I still would have a hard time understanding exactly what their thinking and their reasoning was. So why do we even try? Let's look back to the text itself and see then how we can interpret it. And I agree with you. I think that's why it was left a little bit open, and we have to interpret it within reason.
And there are, and I'll ask the judge's opinion, and Bonnie, your opinion as well, there are certain areas of the Constitution, specifically in the Bill of Rights, that we still struggle with to this day. I mean, the Second Amendment, what does it mean?
Thinking of Heller,
what did they, what did they think it meant? What do we think it meant? Right. What does the common law tell us? What does the statutory law in each state tell us? I mean, what's your thoughts on that, Judge?
Well, his discussion of Heller, I was just a little bit put off by it. I thought he dismissed the Heller majority as just being almost like a political decision. Like that, this is just what they thought of gun rights, and so I don't think you should be so dismissive of it. I think I think that you have to be careful because the living constitutional folks also have certain political viewpoints. As opposed to the originalists or the textualists, whatever you want to call them. So, you can't just dismiss the other side as being, oh, you're just being political when you made that. The quote was being political. It was the so-called conservatives on the bench that decided that. Not quite that simple. I mean, I think there's reasonable arguments for both sides. It came down on the side in that case of a little more of a strict interpretation of the Second Amendment.
But even Heller, to your point, I think if you look at it more closely instead of just saying, okay, it was a pure political decision, even Heller said there are some restrictions that can be placed. Just like we have restrictions on free speech. You can't go into a movie theater and yell fire. And I think it was Justice Scalia who said the Second Amendment doesn't guarantee that you could have an AR-15. It doesn't say that, but it does. They interpret it to mean that every person does have the right to bear arms, but it wasn't without any restriction.
Oh, sure, and I think regulation is part of the job of government. We do, create regulations. Both our legislature and then even regulatory bodies create further regulations, and that's all. That's the job of the legislature is also to interpret the Constitution in many ways too. I mean, certainly reasonable. Regulations on gun ownership is, of course, everyone believes you don't put a firearm into a career violent felon. I mean, that's just not wise. We see what happens.
I mean, a great thing, and this is another term that we've thrown around a little bit, is the federalism of that. The U.S. Supreme Court is saying, this right is not absolute, and we'll leave it to the states to determine how you secure that right. So, like in the state of Massachusetts, there are many hoops to jump through to get a license to carry and then to buy a
Yes.
firearm. There might be other states, and I could be speaking out of turn, but my understanding is like the state of Alaska, you don't need a license to carry. You can go into a gun shop and buy a gun.
A few states, right?
Yeah, so that's a perfect example of federalism, and I'm glad we have it.
Yeah.
You know?
No, I think the brilliant thing about the Constitution is it did allow the states. It gave great authority to the states. You know, Congress shall make no law. Anything that was not, they didn't set out for the federal government to do, they left to the states to do. And I think that's, you know, that's. I mean, that's changed over. I mean, it's through the Civil War. I mean, that sort of, they sort of tightened that up a little bit. But I think the federal government has more power than they probably originally thought that or intended it to have.
I would say that's true too.
You know, but again, you know, we're a different nation than we were 230 years ago, that's for sure, 240 years ago.
And for me, part of the importance of this conversation and part of the reason we're doing this series, and I love so much what you've had to say this evening, and I thank you so much for being here, because I feel like, again, in such a polarized country, and not just our country, but there's a lot of polarization where everything gets politicized, and I think it makes the job for all of us, but especially for judges, it makes it very hard for us to go back to anything that has truth, that has any real meaning, because all we want to do is assign the meaning that we wish it had.
Right.
And I think I have to be willing, I tend, it's no secret, I can say this, I tend more toward the liberal side, but I have to be willing to accept when the Constitution doesn't agree with my own personal point of view, or a ruling comes down, and yes, I can appeal it if it's a personal case, but I feel like we're losing that.
But as citizens, you know, we're a government of the people. I mean, you know, we're a self-governing people. And this is where, if you don't like something in the Constitution, if you don't like a law that the legislature passed, you've got a legislator, you've got a state senator, a state representative, you've got a U.S. senator, you can run for office, you can petition the government. That's one of our First Amendment rights. You can petition the government to change the law, and that's what the great power we have as citizens to be able to do that. And that's what I like to advocate. If you don't like it, if you don't like a particular interpretation of the Constitution, don't just sit and complain about the judges and he's too conservative, he's too liberal, and so forth and so on. You know, take action. Talk to your legislator about you know, potentially introducing a bill that will change something, or you know, eventually you could even amend the Constitution. Who knows what you can do as a citizen? You could. That's what we know. The Constitution is an amazing thing, where we have self-government, where we can actually change our own Constitution if we choose to do so. That's what I think we really should be focusing on. Is if we don't like something, don't complain about it, and don't politicize everything, but just, you know, work towards changing the law, not just our statutory laws, but you know, the Constitution itself, which is, you know, the Constitution is it's a statutory law.
Right. I think that's very motivating, don't you?
Oh, yeah,
like to think about that? I mean, because I think, we tend to sit back and, as you said, we complain about it, or we become immobilized, or we're like, there's nothing we can do.
Yeah, which isn't true.
And that's not how we're set up. So it's really motivating to get that reminder that it is a government, for the people, by the people.
Oh, absolutely. There's countless examples through history where people have made incredible changes to the law, just through sheer effort and determination, and seeing you know, a right that they want to, a wrong that they want to redress and make right. I mean, you look at...
we've seen that in education, we've seen that in gender equality, we've seen that in racial equality.
Particularly in racial equality is a great example of that.
You know, the other thing is, and we talked about how judges at times might be considered conservative, liberal, active, not active. You know, what's refreshing is sometimes when someone gets appointed to the bench, and I'll just point to the U.S. Supreme Court, it might be by a Republican or a conservative, and the judge gets on the court, and they rule in the way that they see the law and how it's presented to them.
And then it makes everyone who put them on their
So when you think about, you know, in our present day court, I mean, John Roberts has sided with what might be considered liberal judges in certain decisions. We go back a little bit, and David Souter from New Hampshire, you know, appointed by George Bush, and he was very liberal on the court. So that is refreshing that they go there, and like you said earlier, and you quoted John Roberts, I'm a referee, or I'm an umpire. calling balls and strikes.
Right.
If you have something that you want to advocate to me in terms of speaking to the attorneys, prove your case. That's the adversarial system that we have.
Right.
So.
And you can't ignore the fact that every judge does bring into the job of being a judge, certain their own personal viewpoints, and this is something we tell jurors now, that we say when you're a juror, you're going to come to this court, you're going to decide this case, and we all have our own biases and our own political viewpoints and so forth. You have to put those aside. You have to. You can't be biased. You have to put aside emotion and biases. You can't decide a case as a juror. And I think the same pretty much applies for a judge. You have to just look at the law, look at precedent, and go from there. And again, if you're wrong, in our system of checks and balances, the legislature can possibly overturn you, the higher court can overturn you. So it all works out in the end. I mean, it really does. It's an amazing system, and I think one of the reasons it's lasted 240-something years now is because of the genius of the founders. And I don't think, that's why I think, we don't know what they were thinking, sure, and they lived in a different time, but you can't deny the fact that what they created here was a work of genius, and it's still going strong after 240 plus years. It's still going strong. I should say 240. I'm going back to the Declaration. It should be it's going back to 1787. So that would be
correct.
That would be 32 years, 232 years.
Yeah, and many people don't know, although I think we've quoted it in previous shows, the Declaration of Rights in Massachusetts, which is our Constitution, predates the U.S. Constitution, and a lot of what. And Judge, back me up on this, a lot of what's in the U.S. Constitution came from Massachusetts.
Came from the Massachusetts Constitution. John Adams. I always tell people that if there's one book that every American should read, it would be David McCulloch's biography of John Adams, which just goes to the brilliance of that man.
Put that on your list.
And also, this is one thing, when I have students come to court, Boy Scouts, high school students, I buy these in bulk and I give them out. This is the Constitution. It also includes the Declaration, the Gettysburg Address. And just to read, I said, read this. It's people think the Constitution is some huge text
that they won't understand.
Yeah, and that's all there is to it. And that actually is, it's a very small document, and you can read it in about 45 minutes. Doesn't mean you're going to understand it, or you're going to. But it's something that every American should be familiar with.
Sure,
absolutely. And that's why we're doing this series, because when we first started, I definitely felt like, oh, the Constitution and these issues—that's way over my head. And as we've been delving into it and going, through each one, I realized, no, it's our duty as citizens to understand as best as we're able. And again, I love the conversation tonight and what you've brought to it, because I feel like if you really take it in, the responsibility and the opportunity that it gives each citizen, it's highly motivating. So I really appreciate that.
Well, we are a self-governing people. We run the show as citizens, and we have to keep that in mind. No matter what politicians try to do or say, we are, in the end, we have the say, the final say.
That's
and we have to, and that I think should hopefully motivate people to get more involved.
Yes. Yes. Well, thank you so much.
I think we've covered a lot of ground, Judge, and you definitely helped in terms of the understanding that we're trying to portray to our viewers out there. Yeah,
it was such an honor to have you here. Thank you so much for joining us.
I really enjoyed it.
And thank you so much for watching us. I hope that if you have questions, you still go ahead if you want and submit them on Facebook, and we can take a look at them later. And thank you so much for joining us.
And we'll see you next time, where we go into freedom of the press, right?
Freedom of the press.
Freedom of the press.
We look forward to it. Thanks again for joining us. Bye-bye.